Introduction: why this video exists. Fear is natural. Fear is human. Fear keeps you alive. But fear does not protect you in court. Every year, thousands of Americans carry firearms believing one dangerous myth: if I was scared for my life, the law will understand. That belief destroys lives. Because the legal system does not operate on emotion, it operates on rules, definitions, and standards that were written long before your worst day ever arrived. When a self-defense shooting happens, the law does not ask, "How scared were you? How fast was your heart beating? Did you feel cornered?" Instead, it asks, was the threat imminent? Was the force proportional? Was the belief reasonable? Did the threat still exist when the trigger was pulled? Did you have a legal right to be where you were? Did you act to stop a threat, not punish it? Miss one of these conditions, just one, in self-defense can legally collapse into manslaughter or murder. This video exists to prevent that. Not to hype fear, not to glorify violence, but to explain, calmly and clearly, how the law actually works when everything is on the line. By the end of this video, you will understand 6 legal conditions where deadly force may be justified, and more importantly, where it stops being protected. Chapter 1: The law does not care how scared you were. Let's start with the hardest truth. Fear is subjective. Law is objective. 2 people can experience the same moment and feel completely different levels of fear. The law cannot rely on feelings because feelings cannot be measured, tested, or proven. That's why self-defense law uses something called the reasonable person standard. This means the court asks, would a reasonable person, with the same information you had, believe deadly force was necessary at that exact moment? Not a brave person, not a paranoid person, a trained special forces operator, a reasonable person. This is why saying "I was terrified" is not enough. You must be able to explain what you saw. Had you heard what the attacker did? The threat was immediate. Lesser force was not enough. Self-defense cases are won or lost after the danger is gone. Inside interview rooms and courtrooms. Chapter 2: Condition number 1. Imminent. 3rd most important word in self-defense law is imminent. Imminent means happening now, about to happen, avoidable, without acting on. A threat that might happen later is not imminent. A threat that already passed is not imminent. Example: legal: a man pulls a gun, points it at you, and steps closer. The threat is visible, immediate, of causing death. Deadly force may be justified. Example: illegal: a man says, "I'm going to kill you one day." No weapon. No immediate action. No imminent harm. Deadly force is not justified. The law requires that the threat be active, not imagined, not predicted, and not emotional. If the attacker turns away, drops the weapon, or retreats, imminence disappears. And when imminence disappears, legal protection disappears with it. Chapter 3: Condition number 2. Ability, opportunity, and jeopardy. Courts often analyze threats using 3 factors. 1. Ability: does the attacker have the physical ability to cause death or serious bodily harm? Weapons clearly satisfy this, but size difference, strength, or multiple attackers can also count. 2. Opportunities: the attacker close enough or positioned to use that ability right now. A man with a knife across the street may not have opportunity. A man with a knife 6 feet away does. 3. Jeopardy: is the attacker acting in a way that shows intent to use that ability? Anger alone is not enough. Movement, words, and actions matter. All 3 must exist at the same time. If one is missing, justification weakens. Chapter 4: Condition number 3. Proportionality is where many good people make catastrophic mistakes. The law requires that force used be proportional to the threat. Deadly force is justified only to stop death, serious bodily injury, forcible sexual assault. You cannot legally use deadly force to stop property theft, verbal threats, or physical altercation. Sexum punches you in a bar fight. Deadly force is likely not justified. But if multiple attackers beat you to the ground and continue, proportionality changes. Context matters. Proportionality is not about fairness. It is about necessity. Chapter 5 Condition number 4. Raisonnableness. If you believe you were justified, the court asks, was that belief reasonable? This is where hindsight becomes dangerous. Prosecutors replay footage. They slow it down. They analyze angles and timing. What felt chaotic in the moment will be dissected frame by frame. That's why articulation matters. You must be able to explain why you believed the threat was real. You believed it was immediate. You believed deadly force was the only option. Self-defense is not judged by perfection, but by reasonableness. Chapter 6 Condition number 5. You cannot be the aggressor. This condition ends more self-defense claims than almost anything else. If you start the confrontation legally speaking, you lose protection. Aggression includes threatening behavior, escalating a conflict, pursuing continuing after disengagement was possible. Even words can matter. If you provoke someone into attacking, then shoot them. Prosecutors may argue you created the danger. Self-defense law protects defenders, not participants. Chapter 7 Condition number 6. The threat must still exist. This condition is brutal, but essential. Deadly force is justified only while the threat exists. Once the attacker runs away, drops the weapon, falls unconscious, stops attacking, legal justification ends. Shots fired after that moment are often the difference between justified self-defense. Criminal charges. This is why emotional control matters. The law allows defense, not revenge. Chapter 8 Why words after the incident matter. What you say after a shooting can destroy a valid self-defense case. Statements like, "I was furious, he deserved it, I didn't mean to kill him, I just snapped," these are legal poison. Self-defense must be framed as necessity, not emotion. This is why lawyers advise, call 911, request medical help, state you were at a ked, request an attorney. Freedom may depend on restraint after survival. Chapter 9 Training your mind, not just your hands. Most gun owners train mechanics. Very few train legal decision make. Knowing the law means recognizing when justification begins, recognizing when it ends, avoiding situations that create legal risk. Mental training saves lives and futures. Closing why knowledge is your real defense. Firearms are tools. The law is the battlefield that follows. You never want to pull the trigger unless life demands it. But if that moment comes, ignorance is not forgiven. The difference between freedom and prison is not bravery. It is knowledge. Like this video, share it with every responsible gun owner you know, and subscribe, because understanding the law is the strongest defense you will ever carry.